The motivation for this paper is quite straightforward. If you think about firms supplying goods to foreign countries, they're typically protected by two types of international agreements. If they engage in foreign direct investment, they're protected by investment agreements against expropriation and related practices. If they engage in exporting, they're of course typically protected by trade agreements, which secure their foreign market access. And increasingly, these two types of agreements are combined with other provisions into comprehensive economic arrangements. And of course, as you also all know, the dispute settlement procedures in these agreements are extraordinarily controversial. You can think of many examples, but when I think about trade agreements, for example, what comes to mind right away is the decision by the US government to block the appointment of judges to the WTO appellate body over frustrations, regarding the WTO dispute settlement system. If you think about the investment disputes, what comes to my mind, at least immediately, are the massive protests we've had here in Europe in 2015 against the CETA agreement and the TTIP agreement, which literally brought hundreds of thousands of people to the street. Of course, some of these protests are against any form of economic globalization, but I would argue that the vast majority object specifically to the deep integration elements, and particularly to this investor-state dispute settlement system, which is a part of these proposed agreements. So to give you some background, what are the key features or what are the key differences between the dispute settlement processes in investment and trade agreements? One key difference is standing. So in investment agreements, we typically have investor-state dispute settlement, whereas in trade agreements, we have state-to-state dispute settlement, which simply means that individual investors can sue foreign governments, but individual exporters cannot. The second difference is the nature of the remedy. So in investment agreements, you can typically sue for cash damages, whereas in trade agreements, the best you can hope for is that you're allowed to also impose tariffs in retaliation. And lastly, it's the remedial period. So there's obviously a time between the occurrence of the violation and then the adjudication of the violation in an investment agreement that would be covered. So an investor, if the investor wins the case, would also be compensated for that, for the foregone profits, for example, during this period. Whereas in a trade agreement, if a tariff is found to be illegal, then the other country can always just remove the tariff and doesn't have to pay anything or pay any form of compensation for the time in between. So what do we do in this paper? We develop parallel models of trade and investment agreements, which we believe capture the key the different problems these agreements are designed to solve. And the main theme is that trade agreements are, of course, government-to-government agreements, which protect market access commitments negotiated between governments, whereas investment agreements are government-to-investor agreements, which solve a commitment problem vis-a-vis foreign investors. And then we use these models to analyze the observed dispute settlement processes from a positive and normative angle. And what I mean by this is we try to see whether we can explain the observed differences in institutional design. And we're also asking whether a change in the institutional design would improve efficiency. And the main point we are making is this one here. So we are finding that in principle, the observed differences in the institutional design across trade and investment agreements can be explained as a consequence of the different problems they are designed to solve. And the kind of overarching intuition is that the fact that these trade agreements are government to government, but the investment agreements are government to investor, really does go a long way in explaining these differences. However, it's not so simple. So it's not simply that ISDS is always optimal in investment agreements in particular, because so the institutional design of trade agreements, that seems to be pretty solid. But when you look at investment agreements, it turns out that they are efficient only under certain parameter restrictions, which may or may not apply in reality and in all circumstances, which does give some support to some of the protests we have seen. So I skipped the related literature. This is a very long paper, which is impossible to present even in 90 minutes, because we basically have a model of trade agreements, we have a model of investment agreements, and then we have these three institutional dimensions: standing, nature of the remedy, remedial period. all I'm going to do today is I'm going to give you a flavor of it. I'm just going to present our trade agreement model and our results on standing. And then based on the intuition that I'm going to develop, I'll basically try to explain just intuitively why things are different in the investment context. So so it's a very stylized setup. We're thinking about a trade agreement now. We forget about we basically just focus on the issue of standing now, forgetting about the remedial period and also about the nature of the remedy. So there's a trade agreement between an importing country and an exporting country, which includes some vague language. And the reason there's some vague language is because we want to have some role for the dispute settlement body, and the role is going to be to interpret this incomplete contract. And this vague language is so there's some states of the world that we index by S. The importer government has a very simple policy choice. It chooses either free trade or protection, and the exporter complainant, which could either be the government or the exporter, as I'll explain in a second, chooses whether to file a complaint with a dispute settlement body. Yeah, here's what I was just preempting. So the exporter complainant could be the government, in which case we have state-to-state dispute settlement, or it could be the exporter, in which case we have exporter-state dispute settlement. Now, this is a very reduced form here, but this would really come out of kind of all standard trade models that we are aware of. So the importer government always gains from protection, and the exporter complainant always suffers from protection. So of course, we're thinking of like optimal tariffs here in this context, where the gamma G is the gain for the home importer government, and the gamma star F is the loss for the foreign agent, where the agent could either be the government or the exporter. And then we separate the states of the world into subsets. So there's a subset of states called sigma P, in which protection is efficient, and there's a subset in which free trade is efficient. And of course, what we have to appeal to here is some political economy or redistributional considerations, and I guess more fundamentally, the incompleteness of a set of policy instruments so that there would ever be a reason to have tariffs. And as I said, what the DSB does, the dispute settlement body does, is it simply attempts to implement the efficient policy based on some noisy signal of what the joint surplus is. And so the way this noise is modeled is that the DSB makes a mistake with some probability, QKS. So this is an inverse measure of the court's quality. And then there are also litigation costs, C for the importer government and C star for the foreign agent. So here's the just the timing of events. So first, the state realizes either free trade is optimal or protection is socially optimal. Then the importer moves, chooses either protection or free trade. In case protection is chosen, the complainant can either call the dispute settlement body or just let it be. And if the dispute settlement body is called upon, it will rule either free trade or protection. And then that's the end of the story. In this particular first setup here, they will just cease and desist and accept. So you can solve this very easily by backwards induction. So you start with the foreign complainant, and of course the foreign complainant is only going to complain if the importer government has chosen protection, and even then only if the expected benefits from filing are larger than the costs of filing. And then you can go one stage back. You can say, well, when does the importer government choose protection? Well, certainly if the filing condition fails, because then you can get away with protection for free, basically, and not getting sued. Or if it holds, so if you expect to get sued, but still the expected benefits of imposing the tariff outweigh your costs. And under the assumption that these costs are not too large relative to what's at stake in these disputes, you can easily show that you have the following kind of outcome here. So I've just tried to illustrate this here. So let me just walk you through. Looks complicated, but it's quite straightforward. So here we have the states where free trade is optimal. Here we have the states where protection is optimal. And this is just the inverse quality of the court. So the court is really bad here and really good there. And basically the setup now is, or the outcome is always that if the court is very good, the right policy is going to arise without any dispute. If the court is very bad, the wrong policy is going to arise without any dispute. And only in the intermediate cases is there going to be a dispute. So the importer government chooses protection and the exporter complainant files a dispute. So then, once we kind of understand how this setup works, we can work out the efficiency loss relative to the first best. So of course, the first best would be if free trade is chosen in the states where free trade is optimal, and protection is chosen in the states where protection is optimal. But of course, you see that this only happens if the court is extremely good in all states. So to the extent that's not the case, and that's of course the interesting case, there are some efficiency losses relative to this first best. And in this very simple setup, there are three sources of efficiency losses. So first, the DSB can of course make a mistake. Second, whenever the DSB, the dispute settlement body, is called upon, there are litigation costs. And third, if the dispute settlement body is very bad, they're going to be basically the wrong choices in the shadow of the DSB, which is basically these two cases here where the wrong policy is chosen. And once we have worked out what the expected efficiency loss is, we can just compare, would it ever, so we can compare that case where the foreign complainant is the exporter to the case where the foreign complainant is the government, and just see which one has a lower welfare loss associated with it. And in order to work this out, we need to make some assumptions, of course. And the first assumption we make, which seems like reasonable to us, is we say, well, the costs of filing a dispute, so the kind of the dispute productivity, if you will, or technology, is the same. So whether you're the exporter or whether you're the foreign government, the cost of filing the dispute is the same. But, and I think this again would come out of any trade model that I know, the expected gains from free trade are larger, or the expected benefit from the removal of this protectionist policy is larger for the exporter than for the government. And of course, you can think about your basic one-on-one trade setup. So of course, if the importer government reduces the tariff, then this increases the domestic price in the exporter country, which is of course good news for the producers, but would be bad news for the consumers. And this would be one of many examples, or for many reasons, why the exporter basically cares more about the exporter firm cares more about the exporter industry cares more about the tariff than the exporter government. So what this means basically is if we think about moving from a system of state-to-state dispute settlement to a system of exporter-state dispute settlement, it basically amounts to the foreign government delegating filing decision to a more aggressive filer, simply because the foreign exporter has more at stake. And let me just check the time. And in terms of the thresholds here, so in the cases in which free trade is optimal, basically this is protectionism is contested for longer, and in cases in which protection is optimal, basically it is also contested earlier. So you basically have a more aggressive filing behavior. So now the question is this good news or is this bad news? And you can see that down here this is definitely bad news, because what's happening is that you're contesting the efficient policy earlier, so that can't be good. What might be good news is this one here, because you're contesting you're contesting the inefficient policy for longer, but that turns out not to be the case. So let me just give you the result, and then I'll give you the intuition. And I think once we understood the intuition, I can then explain to you what happens in the investment case. So the result is that governments, but not the exporters, should have standing to bring disputes in an optimally designed trade agreement. So the optimally designed trade agreement should include SSDS, state-to-state dispute settlement, and not ESDS, exporter-state dispute settlement. And I would say let's forget about the math here. Let me just explain the intuition. So basically, what's going on is the following. So if you think about the government, so if you think about the exporter government, basically from an efficiency point of view, it is already filing too aggressively. And why is this so? This is because it does not take into account the costs of filing on the importer government, both the actual legal costs as well as the costs involved potentially in losing the dispute if you're the importing government, which means that the government is already over-filing relative to the efficient state. So that's one problem that there is. There's this over-litigation feature that's kind of inherent here in this setup. But then also we know that the exporter would be more aggressive in filing than the government. So if the government is already filing excessively, it can never make sense to delegate the filing decision to an even more aggressive agent, which would be the exporter. Yeah. So that's basically the intuition why here we get this result. Now, if I start thinking about investment now, so of course there's a whole new model, and I'm not going to be able to spell it out to you, but I just wanted to give you the intuition. So there, the situation we have is the following. So maybe I should say one more thing. I think then it's maybe going to become clear. So we always have this over litigation problem that I described, but we also potentially have a principal agent problem, because here we have a government to government contract. So if the government were to delegate filing authority to the exporter, there's basically a principal agent problem because the exporter is an imperfect agent for the government. And it makes no sense to kind of add this principal agent problem to the mix because you already have this over litigation problem. But when we think about the investment case, it's a little bit different. So what we can show that in the investment case, it's the way we set this up, but it's basically very similar assumptions. So in the investment case, it's also going to be the case that the investor is more aggressive in filing than the government. And there's also going to be the situation that, of course, there's a principal agent problem, but now the principal agent problem is the other way around, because the agreement is fundamentally a government to investor agreement and not a government to government agreement. So kind of the natural party to upstanding is actually the investor and not the government. And now you have to ask yourself, well, does it make sense, if you will, from the investor to delegate filing authority to the government? And now that could in principle be optimal. Why? Because the investor is over-filing, is filing too aggressively, and the government is filing less aggressively. So it might, under some circumstances, make sense to delegate filing authority to the less aggressive filer, which is the government. So by no means under all circumstances, but under some circumstances. And that's why we get to the conclusion that the state-to-state dispute settlement is always optimal in the context of trade agreements. But investor-state dispute settlement can be optimal, but is not necessarily always optimal in the context of investment agreements. And then we go on and think about the nature of the remedy and the remedial period. But there it's a little bit simpler, so I'm not going to have time now to go through any detail here, but I can just give you the punchline. So the punchline basically is that the way investment agreements are set up and trade agreements are set up, I think there really seems to make sense, at least through the lens of our model. So really the key is, so it's not surprising, if you will, that some of the main policy controversies have been arising around this issue of standing.
I mean, this is more of a general one. In some of the trade agreements, for example, the EU-Singapore one, they have a procedure of first good faith consultation, and then they have an arbitration panel that is constituted, is created for that. Is that something that is isomorphic to your dispute settlement mechanism, the one that you have what I mean is your setup applicable also to this sort of arbitration panels, or there's something specific to the dispute settlement that you have in mind?
No. So we're actually thinking about these I have a weird echo. We are thinking specifically about these arbitration panels. So I think this good faith consultation stage, we don't have it in here explicitly, but I just called it dispute settlement body, but I don't mean the dispute settlement body in the sense of the WTO or anything like
Okay.
that. We really mean like the way investment arbitration works in reality. And we just imagine that something similar might, in principle, be also applied in a trade context.
Okay, thank you.
Would you have in mind also the possibility that the WTO is extended to also investment disputes and investment protection? Do you envisage such a complex multilateral framework that could take care of both?
I mean, if this is like a question about the model, or probably more in general, right? I think that with the WTO, we would hope that it could take care of anything. Even the tariffs, it doesn't seem to be able to take care of that. And also, I guess in the past we've seen that bundling all these issues together wasn't always a good thing. Now should the WTO, is there a reason to link these issues? So I guess that's one way I could relate it to our model. So in principle, you might wonder if there's some issue linkage, if there's some reason that you really think about these two parts of modern trade agreements, the investment part and the trade part together in one setting, as it, by the way, happens in many of these modern trade agreements. If you think about the CETA agreement, or if you think about TPP or the new NAFTA, they all have investment and trade dimensions. So we don't really have much. I think it's a super interesting question, but honestly, we don't have much to say about this in our paper, because we really think about these two issues here separately. And one interesting point, though, that I can make and that we do discuss in the paper is that, of course, so I didn't have time to go through this, but of course, in the investment context, we're thinking of a commitment problem and in the trade context, we're thinking of a market access problem. But of course, there's some isomorphism there. So if you think of the standards, say you think of a standard model of horizontal FDI, of course, there you also have some market access issues. Or if you think of a standard metals model, say, you also have some sunk investments in exporting. So the commitment issue could also arise in a trade context, and the market access issue could also arise in an investment context.
Okay, Ralph, thank you very much. I think we are on the same line. We have a question by Daniel Treffler. He says, your paper is very interesting, and this investor trade difference in agreement is too often ignored. And there is the Lighthizer complaint is very specific, judicial overreach. He's not complaining that integration is too deep as negotiated, but that the WTO has made it deeper without US permission. It's not the topic of your paper, but can you cast light on this?
So I completely agree. So the Lighthizer complaint is that the WTO is over litigious, that there's too much litigation going on. And I mean, we can cast light on this in our paper, but I don't think in a particularly deep way. So what we can say, for example, is if the dispute settlement body is of sufficiently bad quality, then of course having a trade agreement with a bad dispute settlement body is worse than not having a trade agreement at all. So to the extent that you believe that the WTO dispute settlement body is really bad, then you might not want to participate in the WTO at all. So in some sense, we have a point of contact in what Lighthizer is saying, but perhaps not quite as richly as he has in mind.
Okay, thank you very much.
So one thing that specifically refers to the investor states dispute settlement bodies is that it's not about necessarily quality, but it's also about their bias, that they might be biased towards the investors because these are professional attorneys that may have long-term interests in dealing with certain firms. Do you also deal with this kind of biasness in your model?
So we don't. It's a very, very good question, and I agree with you that that's salient in the public debate. So in this particular paper, we don't, but I guess we could. But I have a separate paper with Giovanni Maggi, not on investment agreements, but on regulatory cooperation, but there the whole paper is about political economy and the sense that the sense there is that basically corporate interests are dominating these negotiations, and therefore come to conclusions that might not be in the interest of society at large. So I'm working on this. I have a bunch of papers now on deep integration, because I do think that's kind of a very, very important feature of real world trade agreements, which is not thought about enough in the trade policy literature.